Counsel, do you wish to be heard? You're currently muted though, counsel.
Can you hear me now?
Yes, sir.
Your Honor, this is a nonviolent offense. I believe my client has no prior criminal record. He has been a resident of Polk County since 2015. If he was released, he would live with his parents. He does have a job. He works with his parents in a real estate business. Again, this is a nonviolent offense. The alleged incident was supposedly to have happened in January of 2025. Since January of 2025, he's been out and he's committed no other crimes. So I do not believe that he would be considered a danger to the community, which would the state would need to be to prove that in order to hold him without bond.
Any response?
Well, that's what the hearing is for, Judge. Trafficking may not be a violent crime in and of itself. State would, in argument, provide that the types of activities that tend to go along with drug trafficking are violent in nature, including violence towards people, towards the community itself, and that the drugs themselves do present a danger to the community. The legislature set this crime aside as one qualifying for pretrial detention. If the court is inclined to grant a bond, it still should be set for detention hearing next Thursday. Thank you.
All right, then as it relates to the charge of trafficking cannabis, the motion for pretrial detention is well taken. The defendant will be held no bond until the hearing scheduled for May 21st at 1 p.m. with the A2 division. As to the charge of maintaining a dwelling for drug trafficking, bond amount will be $10,000, and as to the charge of possession of drug trafficking, the bond amount will be $1,000. Counsel, anything else?
Nothing else for me, Your Honor. Thank you.
All right, thank you, sir.
Excuse?
Yes, sir. All right, if the bailiff would have everyone stand to be sworn, please.
All right. Y'all rise, please. All right. Raise your right hand, guys.
What told the whole truth, say I do? I do. I do.
That's a lot I do.
I do.
All right, thank you very much. Folks, my name is Bob Grant. I'm going to be the judge for the first appearance today. When your name is called, come forward. We're only going to go over a few things today because it's just first appearance. First of all, I'm going to ask you if you need the service of the public defender. If your answer is anything other than no, we'll talk about your financial situation to determine if you qualify for the public defender. Additionally, we will look at the probable cause affidavit to determine if there is probable cause, and if there is, we will determine if there are any appropriate bond or release conditions. Please do not talk about the facts of your case in any way whatsoever. Everything you're saying is being recorded. You're under oath, and the state attorney would love for you to talk all about your case, but that's not a good idea for you to do. So if you're fixing to say something you think it might somehow be related to your case, don't say it. With that, we'll begin with Corey. Oh, I'm sorry. Who do we have?
Step over here. He was an arrow. Step over here.
We've got the
Over here. What names?
Timothy
Wilson.
I don't have.
Timothy Wilson.
I don't have Wilson as an add-on either.
We do not have a Timothy Wilson as an add-on.
Logan Timothy Wilson.
Either way, you don't have Wilson at all. We don't even have the volleyball Wilson. Nothing. So sorry, sir, we can't help you today.
That's not necessary.
All right, so we'll move to South County. Corey Boland. Is Mr. Boland there?
Yeah.
All right, Mr. Boland, you were here on charges.
Reading.
Yes, ma'am.
I'll ask you heard already as well.
Yes, sir. Sir, on your previous charges or cases you're currently out on bond for, did you have the public defender representing you?
I haven't spoken to no public defender.
I meant for your previous cases.
Yes, sir.
All right, well, do you want me to go ahead and appoint the public defender for this one as well?
Yes, sir.
All right, I will appoint the public defender to represent you. State wish to be heard.
Yes, Your Honor. With regard to the count that's on the docket for today, that is a enumerated dangerous offense under 907-041-5A. State is filing a motion for pretrial detention and providing a hard copy to the appointing counsel. May I approach?
Yes, sir.
Respectfully request the court review this motion for facial sufficiency, and if so found, hold the accused no bond pending a hearing on this motion, which should be set next Thursday at 1 o'clock on the A2 docket. State will also request Parker holds on any qualifying open cases, including 26 CF 3155. Thank you.
All right, the motion is well taken. The defendant will be held no bond on the charges before the court today. Additionally, the defendant has open cases 26 CT 2530, 2529, and 26 CF 3155. Pursuant to Parker v. State, bond will be revoked. He will be held no bond, and the public defender was not previously appointed. They will be appointed for those charges as well. Good luck, sir.
And Your Honor, Deborah Goins, on behalf of Mr. Boland, I just wanted him to know that a lawyer will be there at that hearing on next Thursday.
And on the A2 division at 1 o'clock.
Yes, sir, 521.
Christopher Bussey.
As we heard on this one.
Mr. Bussey, you're here on charges of burglary with assault or battery therein. Do you need the service of the public defender?
Yes.
All right, I will appoint the public defender to represent you. State.
Your Honor, this is a burglary alleged of a dwelling, so it is a qualifying dangerous offense. It is also a first-degree felony punishable by life. The state is requesting the court consider holding the accused no bond. If the court is not so inclined, then the state will announce an intent to file a motion for pretrial detention and request he be held 24 hours from the state to file that motion. Thank you. And I also noted, it appears the warrant was issued. I know the case number is a little older, but it looks like the warrant was issued all the way back in 2024.
Well, as it relates to this, based on the nature of the case, the defendant will be held no bond and public defender is appointed. Good luck, sir. Jeremiah Butler. You were here on charges of aggravated battery causing bodily harm or disability. There is probable cause for the charge. Your bond amount will be $10,000. And if you're able to bond out, there'll be conditions of pretrial release. Those conditions will include the following: you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You would have no contact with the alleged victim. Additionally, you're currently on probation in 25 MM 5639. That probation will be, a standard warrant will be prepared for a violation of probation. And do you need the public defender to represent you, sir?
No.
All right. Good luck, sir.
That was 25.
5639. Xavier Echevarria.
Yes, Your Honor.
Sir, you're here on an allegation of a violation of probation for which you will be held no bond. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir.
Thank you. Appreciate it.
Max Esperance.
He was combative.
All right, would you let him know, please, that I'm going to appoint the public defender to represent him, and his charges on assault on a law enforcement officer, the bond will be $5,000, possession of drug paraphernalia, $1,000, and possession of cannabis, $1,000.
Yes, sir.
Dion Gordon.
Yes, sir.
Sir, you're here as a result of a warrant out of Marion County. You'll be held no bond on that charge. We will set it for next Friday for a follow-up to make sure that Marion County has done what they're supposed to do, or else we'll do what we have to do. Good luck, sir.
Your Honor, may I confirm that name again?
Gordon.
Good, thank you, sir.
Christopher Hicks. Mr. Hicks, you're here on two KPI? Judge Carpenini determined that on two different cases, you would be held no bond for failure to appear for an arraignment. There will be a 5-day hearing scheduled. Apparently that's scheduled for May 19th.
Your Honor.
9 a.m. And do you need the public defender to represent you?
Oh, Your Honor.
All right, good luck. DeMarco Maestra.
Yeah.
Sir, you're here on a charge of domestic violence battery, for which there is probable cause. Your bond amount will be $2,000 as a result of an ICE hold, so you will be held. You are subject to immigration detainer. Additionally, if you're able to bond out, there'll be conditions of pretrial release. Those conditions will include the following: you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You have no contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. Sir, do you need the service of the public defender?
Yes.
All right, I will appoint the public defender to represent you. Good luck, sir.
Your Honor,
Thank
he's
you.
already. Oh, I get, he's already, our office is withdrawn on, it may not be this case, that's true. So we need to be appointed
Yeah.
first. Thank you, sir. Thank you.
Jade Monday.
Yes, sir.
Mr. Monday, you're here on, was a warrant signed by Judge Yancey.
And if I may, Your Honor, there is a superseding indictment with a true bill filed 5/14/26, which was yesterday. The top count is a capital felony. The state is asking the court to hold a no bond on that capital offense. If the court is not so inclined, they'll request 24 hours to file a motion for pretrial detention. It is a qualifying dangerous offense. Thank you.
Well, I am not the appellate court for the chief judge, so I'm going to go based on his warrant, which shows that for the 4 counts, the defendant will be held no bond.
Yes.
Mr. Monday, do you need the service of the public defender?
No, sir.
All right, good luck, sir. David Morris?
Yes, sir.
Mr. Morris, you're here on a charge of first-degree murder. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. State wish to be heard.
Yes,
If you'll allow me, Your Honor, Deborah Goins on behalf of the Public Defender's Office. Mr. Morris has already been appointed to regional counsel. And I believe that Mr. Ladner is the attorney of record. I checked that in the clerk's computer because there's a co-defendant coming up. And so I believe he already has.
You're right. I just saw it on there.
All right, sir.
and warrant I received is they intend to withdraw as well.
All right.
But this again, an indictment with a true bill was filed yesterday, 5/14/26 is a capital offense. State's requesting the court hold a no bond. If the court thought so inclined, then request 24 hours to file a motion.
All right. Well, as it relates to this case, a warrant was issued and he is to be held no bond on the charge.
Yes.
And currently it's regional counsel, but it sounds like it'll be a different attorney representing you, sir. Good luck, sir. Juan Hector Mujica.
Yes, sir.
Sir, you're here on charges of a driving license suspended or revoked with a bond of $5,000, grand theft of a motor vehicle with a bond of $5,000, possession of cannabis, possession of drug paraphernalia with a bond of $1,000 each, possession of, willfully refusing to accept and sign a citation with a bond of $250, tampering of physical evidence with a bond of $5,000, possession of methamphetamine, battery on a law enforcement officer and resisting an officer with violence with a bond of $5,000 each. Then possession of drug paraphernalia with a bond of $250 and resisting an officer without violence with a bond of $1,000. Sir, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Jim Neal? Mr. Neal, you're here on a charge of unlawful possession of a shopping cart. Your bond amount is $250. Additionally, you're currently out on pretrial release or bond in 25 CF 10106. Do we know what that charge is?
I can look it up in a moment.
Okay. Well, I'm not going to revoke your bond on that charge. They're completely separate things. Sir, do you need an attorney to represent you for this case?
Yeah.
All
Your
right.
Honor, yeah.
Ms. Goins, is this one the public defender's office would represent on?
Is it an ordinance?
It's a statute.
Yeah, I think it's a statute.
All right, then public defender will be appointed. Good luck, sir.
Thank you, sir.
William Newton.
Yes, we heard on this one.
Mr. Newton, you're here on a charge of first-degree murder. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. State wish to be heard.
Thank you, Your Honor. This is a capital felony. It is qualifying dangerous offense. The state is requesting defendant be held no bond based on the charge. If the court is not so inclined, we will request 24 hours, file a motion for pretrial detention. Thank you.
All right, pursuant to the case signed by the Honorable Judge, Chief Judge Jay Yancey, defendant will be held no bond on this charge. Good luck, sir. Marion Sloan. Mr. Sloan, you're here on charges of resisting an officer without violence and trespass with a bond of $1,000 each. Do you need the service of the public defender?
Yes, Your Honor.
I will appoint the public defender to represent you. Good luck, sir.
Yes, sir.
Don, is it Vistacci?
Yes.
Mr. Vistacci, you're here on charges of defrauding a financial institute with a bond of $10,000, displaying a blank or forged stolen driver's license or ID, and grand theft of property value with a bond of $5,000 each. Do you need the service of the public defender?
Yes.
I will appoint the public defender to represent you. Good luck, sir. Is that everyone in South County?
Yes, sir. Good luck, sir.
All right, thank you. All right, then we'll move to Central with the females, beginning with Anissa Alfred. Is that you, ma'am?
Yes, sir.
Ma'am, you're here on charge of possession of cannabis and possession of drug paraphernalia with a bond of $1,000 each. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, ma'am.
Thank you.
Kamora Anglin.
Yes, sir.
Ma'am, you're here on a charge of domestic violence battery for which there is probable cause. You are recommended for pretrial release, which means you would not have to post a bond as long as you follow all the conditions of pretrial release, which would include that you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You would have no contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. Ma'am, can you agree that you'll follow all the conditions and show up for all your court dates?
Yes, sir.
Additionally, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, ma'am.
I've been released today.
Ezria Brown?
Yes, sir.
All right, ma'am, you're here on a charge of domestic violence battery. There is probable cause for the charge. Your bond amount will be $1,000, and if you're able to bond out, there'll be conditions of pretrial release, which will include the following: that you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You would have no contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. Ma'am, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, ma'am.
Thanks.
Jocelyn Cato?
Yes, Kodo.
Photo, thank you. All right, ma'am, you're here on 5 counts of violation of probation for which you'll be held no bond. Do you need the
Yes.
service of the public defender?
Yes, sir.
I will appoint the public defender to represent you.
If I may, Your Honor, with Ms. Cotto, she's actually set for F7 on Monday, the 18th. And she's one of the clients that was given to cover this week.
Okay,
So I was wondering why she would be here at first appearance since she's already set on 5/18.
Well-
Maybe the court doesn't know that answer.
I don't.
Because there's another person who's in the same category.
I guess we'll.
So- But that's fine. She's already had the PD that been appointed to her.
Good luck, ma'am.
Thank you, ma'am. Thank you, sir.
Julie Enos?
Yes, Your Honor.
Ma'am, you're on a charge of abuse of a child without great bodily harm. There is probable cause for the charge. Your bond amount will be $5,000, and if you're able to bond out, there'll be conditions of pretrial release, which would include the following: you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You would have no contact with the alleged victim. Ma'am, do you need the service of the public defender?
No, Your Honor.
Good luck.
Thank you.
Jasmine Ford?
Yes, sir.
Ms. Ford, you're going to charge domestic violence battery for which there is probable cause. Your bond amount will be $1,000, and if you're able to bond out, there'll be conditions of pretrial release, which will include the following: you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You'd have no contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. And do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck.
Thank you.
Jody Koenig?
Yes, sir.
And you're here on charges of a violation of probation for which you'll be held no bond, and a domestic violence battery charge with a bond of $1,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Additionally, you would be placed on pretrial release, and that would start immediately. You would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. No contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. Good luck, ma'am.
Yeah.
Bonnie Lynn?
Yes, Your Honor.
You're here as a result of an allegation of a violation of probation for which you'll be held no bond. Do you need the service of the public defender?
Yes, please.
I will appoint the public defender to represent you. Good luck, ma'am.
Thank you.
Crystal, you don't have Crystal Locke there, right? Melanie Olmsted?
Yes, sir.
You're in charge of resisting officer without violence and possession of drug paraphernalia with a bond of $1,000 each, and possession of methamphetamine with a bond of $5,000. Do you need the service of the public defender?
I definitely need a public defender because I didn't have
I'll
anything.
definitely appoint one. Public defender is appointed. Good luck, ma'am. Megan Palmer?
Yes.
Ms. Palmer, you're here on charges of possession of drug paraphernalia with a bond of $1,000, possession of methamphetamine with a bond of $5,000. Additionally, you're currently out on bond in 26 CF 3111. Good Parker v. State, that bond will be revoked. You will be held no bond. Do you need the service of the public defender?
Yes, Your Honor.
I will appoint the public defender to represent you. Good luck, ma'am.
Thank you.
Ricky Prine,
Yes, sir.
and you're here on charges of creating or maintaining a nuisance with a bond of $250, failure to obtain a permit to comply with law with a bond of $1,000, and dumping litter on private property with a bond of $5,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, ma'am.
Thank you.
Marisol Rivera Torres.
Yes, sir.
And you're here as a result of a warrant out of Orange County. The bond amount is $5,000, so you can bond out, or we can see what happens next Friday to see if Orange County's done what they're supposed to do. Good luck, ma'am.
Thank you.
H.O. Rivera.
Yes, sir.
And you're here on charges of grand theft of a motor vehicle with a bond of $5,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, ma'am. Tanya Shivers.
Yes, sir.
Ma'am, you're here on a charge of domestic violence battery. There is probable cause for the charge. Your bond amount will be $1,000. If you're able to bond out, there'll be conditions of pretrial release, which will start immediately. Those conditions would include the following: she would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You may have contact with the alleged victim, but it may not be physically or verbally threatening or violent in any manner whatsoever. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, ma'am.
Thank you.
Jennifer Wiggins. Did I miss one? Who did I miss? What's your name, ma'am?
Sean Jackson.
Alicia Swan Jackson.
Oh, okay. I had that you had bonded out. I guess not.
I guess it's in process.
All right. Well, the bond amount is $5,000 on the charge. Do you need the service of the public defender?
Yes.
I will appoint the public defender to represent you. Good luck.
Thank you.
And then Summer Swanger,
Yes, Your Honor.
and you're on charges of DUI with a bond of $1,000, refusal to submit to a blood alcohol test with a bond of $1,000, criminal mischief $1,000 or more with a bond of $5,000, resisting an officer without violence with a bond of $1,000, and destroying or interfering with a firefighter or their equipment. Your bond amount for that will be $5,000. Ma'am, do you need the service of the public defender?
Yes.
I will appoint the public defender to represent you. Good luck, ma'am. And then Jennifer Wiggins.
Yes, sir.
All right, Ms. Wiggins, you're here on a charge of false ID given to a law enforcement officer with a bond of $1,000 and driving the license suspended or revoked with a bond of $5,000. Additionally, currently on probation in 25 CF 3026, 25 MM 4098. That bond will be revoked and you will be held no bond. That's a standard warrant on the violation of probation. You will be held no bond on the violation. For all of this, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, ma'am.
Judge, I got it 25 CF. Stand for what was it?
3026. And what is your name, ma'am?
BABB,
All right, that is our add-on.
Hernando County.
Okay, so you've got a active warrant. Is it Hernando?
It is her name.
What's the bond amount?
No bond.
All right, so it is Hernando County. You are being held no bond. So
What's the
hopefully they'll come
charge?
get you pretty quickly. But if
What's the
not,
charge?
we'll have to wait until next Friday and then they'll come see you. Or if they don't do what they're supposed to do, then we'll take care of it on this end.
What's the
So-
charge?
Throwing a deadly missile at, within, or into an occupied vehicle. Good luck, ma'am. All right, then moving to the males at Central, beginning with Gerald Allen. Sir, you're going to charge a false ID given to a law enforcement officer. Your bond is $1,000. Do you need the service of the public defender?
No.
Good luck, sir. Chalmers Bishop.
He's still, in the bed, the outside.
All right, I'm going to go ahead and appoint the public defender to represent him. As to the charges of possession of methamphetamine and keeping a public nuisance, the bond is $5,000 each. Possession of drug paraphernalia, possession of cannabis, the bond is $1,000 each. Use or display of a firearm during a felony offense, the bond is $10,000. Possession of an altered firearm, the bond is $1,000. And then for the other 50 counts, the bond will be $5,000 as to each of those counts.
Your Honor, if Deborah Goins, if I may, what did they say the reason was he was here?
He's bedridden, essentially. He's in infirmary.
Thank you.
Jack Bohannon? Is that you, sir?
No, Your Honor, he was taken to South County, so he must be in transit somewhere along the way.
Oh, okay. Well, whoever has the duty this weekend can take care of that. Daniel Campos O'Brien, is that you, sir?
Yes, sir.
All right, sir, you are here on 2 counts of violation of probation for which you will be held no bond. Resisting an officer without violence with a bond of $1,000. Domestic violence by strangulation, bond amount would be $5,000. Additionally, if you're able to bond out, there'll be conditions of pretrial release, which will include the following. So you would not use, possess, or carry any firearms, weapons, guns, knives, or ammunition. You'd have no contact with the alleged victim, but you may, well, the alleged victim does want to have contact, so you may have contact. It may not be physically or verbally threatening or violent in any manner whatsoever. Okay, hold on a second. Sorry, we've already got a judge on this. Judge Williamson has determined that you would have no contact with the alleged victim. So you got to abide by that condition. You can have no contact at all. Other than you can go within 48 hours of release to get any personal items, as long as you have law enforcement with you. Sir, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Jeremy Clark?
Yes, sir.
Sir, you're here on charges of maintaining a nuisance with a bond of $250, failure to obtain a permit with a bond of $1,000, and dumping litter on private property with a bond of $5,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Yes.
First one, Joseph?
Yeah. Yeah. Are you Mr. Colazzo?
Yes, sir.
Mr. Colazzo, you're here on charge of possession of drug paraphernalia with a bond of $1,000 and possession of methamphetamine with a bond of $5,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Charles Cotton?
Yes, Your Honor.
Mr. Cotton, you're here on charges of petty theft with a bond of $250. Do you need the service of the public defender?
Sure, Your Honor, yes.
I will appoint the public defender to represent you. Good luck, sir.
Thank you.
William Dobson?
Yes, sir.
Mr. Dobson, you're here on charges of maintaining a nuisance with a bond of $250, failure to obtain a permit with a bond of $1,000, and littering with a bond of $5,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Jose Don Juan?
Yes, sir.
Not ask to be heard on this one, too.
Yes, sir. You're here on charges of extortion, criminal mischief, and written threat to kill or harm another. Do you need the service of the public defender?
Oh, yes, sir.
I will appoint the public defender to represent you. State.
Your Honor, while there are charges in this case that are nominally qualifying, state is not filing a motion for pretrial detention. However, the state is requesting a condition of the bond be that the defendant have no access to the internet. It appears that the alleged communications were persistently done over several internet vehicles. Thank you.
All right, sir. Well, as it relates to these charges, as to counts 1 and 3, the bond will be $10,000 each. As to count 2, it'll be $250. If you're able to bond out, there'll be conditions of pretrial release. Those conditions will include the following. You would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You would have no contact with the alleged victim. Additionally, you would not have possess, access, or use any computers or other electronic devices with internet or intranet capability, and those requirements begin immediately. So good luck, sir.
Thank you.
Say, reappointed on him.
Yes.
Thank you, sir.
Joseph Dorismond?
Yes, sir.
All right, sir, you're here on a charge of domestic violence battery. There is probable cause for the charge. Your bond amount will be $1,000. If you're able to bond out, there'll be conditions of pretrial release, which will include the following. You would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You'd have no contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. Sir, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir.
Hey, excuse me, sir. So, you said no contact with the victim? That you said or no? Okay. All right.
Joseph Evans?
That's better.
Mr. Evans, you're here on a charge of trespass. Your bond amount will be $1,000. Do you need the service of the public defender?
Leading, you're leading.
I will appoint the public defender to represent you. Good luck, sir.
Thank you.
Mark Valero,
Present.
are you here on charges of aggravated assault and domestic violence battery? There is probable cause for the charges. Your bond amount as to the first charge will be $5,000. As to the second charge, which is the domestic violence battery, the bond amount will be $1,000. If you're able to bond out, there'll be conditions of pretrial release, which will include the following. You're not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You have no contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. Sir, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Samuel Goez Para,
Yes, sir.
you're here on charges of driving while license suspended or revoked. Your bond amount for that charge, well, sir, you're recommended for straight pretrial release. Apparently, you have no known criminal history. Conditions of pretrial release would include that you would show up for all your court dates, that you would abide by all the conditions of pretrial release. And if you do those things, then you can be released without having to post a bond. Can you agree to do those things?
Yes, sir.
All right, then we will show this as straight pretrial release. Good luck, sir.
Thank you.
What's that? Oh, I'm sorry. Yeah, do you need the service of the public defender?
No, sir.
Good luck. David Graff.
Yes, sir.
Mr. Graff, you're on charge of possession of drug paraphernalia with a bond of $1,000, possession of methamphetamine with a bond of $5,000, 3 counts of violation of probation for which you'll be held no bond. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Darian Jenkins.
Yes, sir.
Mr. Jenkins, you're here on charge of possession of cannabis, possession of drug paraphernalia with a bond of $1,000 each, possession of amphetamine with a bond of $5,000, and a delinquent in possession of a firearm with a bond of $10,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Tonia Jones?
Jackanaya. Yes, sir.
Ekanaya, thank you. Sir, you're here on charge of possession of drug paraphernalia with a bond of $1,000 and possession of fentanyl with a bond of $5,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Joseph Kelly?
Sir.
Mr. Kelly, you're here on a charge of simple battery. There is probable cause for the charge. Your bond amount will be $1,000. Do you need the service of the public defender?
Yes, I do.
I will appoint the public defender to represent you. Good luck, sir.
Here.
Do we have Lawrence Lilly?
Yes, sir.
Mr. Lilly, you're here as a result of a warrant signed by the Honorable Judge Stacy Kaler for failure to appear for mandatory docketing. Judge Kaler has determined that you will be held no bond on this charge, and a 5-day hearing is scheduled for you on May 19th at 8 a.m. And public defenders previously been appointed. Good luck, sir. Tyler Martinez,
Yes, sir.
sir, you're here on charges of keeping a shopper vehicle for the use of drugs and possession of drug paraphernalia with a bond of $1,000 each, and then possession of cannabis with intent to sell, possession of cocaine, possession of oxycodone, possession of cannabis resin, and possession with intent to sell a legend drug without prescription. The bond for each of those is $5,000. Do you need the service of the public defender?
Oh, yes, sir. And if I could show proof that I got a prescription for the promethazine, would that charge get dropped?
Oh, you need to talk to your attorney about that.
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Arvil McConnell?
Yes, sir.
So you're here on charges of failure to have a required endorsement on your driver's license and attaching an unassigned tag with a bond of $250 each, as well as unregistered failure to register a motor vehicle with a bond of $250. Additionally, you have charges of possession of drug paraphernalia with a bond of $1,000, and then possession of a counterfeit motor vehicle registration bill of sale. There are 5 counts of that, and the bond for each of those is $5,000. Sir, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Yeah.
Yes, is there a bond appointed on the alleged manufacturer?
Yes, $10,000, sorry.
10,000, thank you.
Buddy McGee,
Yes, sir.
McGee, you're here on a charge of tampering with electronic monitor device and grand theft. Your bond as to each of those will be $5,000. Additionally, you would be placed on pretrial release. We'll try a new monitor with house arrest conditions, all exceptions allowed. Additionally, sir, you're currently out on bond on 26 CF 2446. That bond will be revoked pursuant to Parker v. State. You will be held no bond. Sir, for these charges, do you need the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. GPS monitor, house arrest conditions.
Yes, sir.
Thomas Miller.
Yes, sir. Good afternoon, Your
You're
Honor.
here on charges of grand theft with a bond of $5,000. Additionally, you're on probation currently in 25 CT 5704. That probation, I'll do instance your warrant on that. You will be held on violation of probation, no bond. And for all of these charges, do you need the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir.
Yes, sir. Thank you.
Jose Rosales, is that you?
No,
Jesus,
no,
what's
Your
your
Honor.
name?
Leandro Pulido.
Oh, there it is. All right, sir, you're on a charge of domestic violence assault. There is probable cause for the charge. The bond amount will be $1,000. If you're able to bond out, there'll be conditions of pretrial release, which would begin immediately. Those conditions would include the following: you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You'd have no contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. Sir, do you need the service of the public defender?
Yes, Your Honor.
I will appoint the public defender to represent you. Good luck, sir.
Thank you, Your Honor.
Now, Jesus Rosales.
Yes, sir.
All right, sir, you're here as a result of a warrant out of Pinellas County, failure to appear for a pretrial hearing.
Smith.
Bond is $2,013. So if you're able to bond out, you can get out today. If not, then we'll set it for next Friday to see what happens at that point. Good luck, sir.
Thanks, sir.
Jacob Schaefer.
Yes, sir.
Mr. Schaefer, you're here on charges of domestic violence, aggravated assault, and domestic violence battery. There is probable cause for the charges. Bond amounts will be $5,000 and $1,000. And if you're able to bond out, there'll be conditions of pretrial release. Those conditions will include the following: you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You may have contact with the alleged victim, but it may not be physically or verbally threatening or violent in any manner whatsoever. Sir, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir.
Thank you.
Mark Scott.
Yes, sir.
Sir, you're on a charge of driving a license suspended or revoked with a bond of $250. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir.
Thank you.
Gregory Smith.
Yes, sir.
Mr. Smith, you're here on a charge of resisting officer without violence. The bond on that charge is $1,000. Do you need the service of the public defender?
Yes.
I will appoint the public defender to represent you. Good luck, sir. Dwayne Stackhouse.
Yes, sir.
Sir, you're here on charges of tampering with electronic monitor device and criminal mischief. Your bond amounts will be $1,000 and $250. And if you're able to bond out, there'll be conditions of pretrial release, which will include the following: that you would be subject to GPS monitoring, house arrest conditions, all exceptions allowed, that you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. Sir, do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir. Not to be released until fitted. Andrew Schwezik.
Cizik.
Cizik. All right, thank you. Mr. Cizik, you're here on a charge of domestic violence battery. There is probable cause for the charge. Your bond amount will be $1,000, and if you're able to bond out, there'll be conditions of pretrial release. Those conditions would include the following: that you would not use, possess, or carry any weapons, firearms, guns, knives, or ammunition. You'd have no contact with the alleged victim, but you may return to the victim's residence one time only within 48 hours of release, accompanied by law enforcement to retrieve any personal items. Sir, do you need the service of the public defender?
Yes.
I will appoint the public defender to represent you. Good luck, sir. Lance Tate.
Yes, Your Honor.
Sir, you're here on a charge of disorderly intoxication with a bond of $250. Do you need the service of the public defender?
Yes.
I will appoint the public defender to represent you. Good luck, sir.
Thank you.
Kamari White.
Yes, sir.
Sir, you're here on 2 counts of violation of probation for which you will be held no bond. Do you need the service of the public defender?
No, sir.
All right, good luck, sir.
Thanks.
Harry Williams. Mr. Williams, you're here on charges of no driver's license with a bond of $250. and possession of a weapon or ammunition by a felon with a bond of $5,000. Do you need the service of the public defender?
Yes, sir.
I will appoint the public defender to represent you. Good luck, sir.
Thank you.
All right, thank you very much.
All right.
All right, thank you. Please be seated. Okay, can the interpreter hear me?
Yes, Your Honor. Good morning.
Oh, good morning. Thank you. I think we have at least two people, so we better do consecutive for this part. And I am just going to go straight through the victim's rights advisement. You have a copy in
Yes.
Spanish, right?
Yes,
Okay.
I do, Your Honor.
Okay, thank you so much. All right, this is the 11 a.m. initial appearance calendar for May 15th, 2026.
Este es el calendario de la comparecencia inicial del día de hoy, 15 de mayo del 2026.
The court's orders for the taking of fingerprints and DNA samples made on the 2 a.m. calendar on the first of the month will also apply to these hearings.
Órdenes emitidas con respecto a la toma de huellas dactilares y muestras de ADN emitidas el primero del mes aplican en todos los casos.
I will now read the victim's rights advisement in the event there are any victims present here at the court observing the hearings or observing them remotely.
Ahora les voy a leer a todos los derechos de las víctimas en caso de que haya alguna víctima observando estas diligencias judiciales.
If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, the right to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling, and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you've not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office.
Si usted es la víctima de un delito pendiente, de un caso pendiente en este tribunal, se les informa que tienen derechos de justicia de un debido proceso según la ley de Arizona, que entre otros incluye el derecho de ser tratados con respeto, justicia, dignidad, a un juicio sin demora, a la resolución pronta de este caso, a estar presente en diligencias judiciales, elegir si quieren ser entrevistados o no por el acusado o el abogado del acusado, a ser escuchados antes de que el juez tome decisiones de liberación, negociación de algún convenio, citación e imposición de la pena y de recibir reparación del daño de parte de la persona que haya sido condenada por causarle su pérdida económica. Si todavía no ha recibido copia escrita con todos los derechos de las víctimas, por favor póngase en comunicación con la Procuraduría del Condado en la Oficina de Atención a las Víctimas.
All right, Mr. Coronado Medina, you can come to the podium, and Mr. Leyva Garcia, if you'll wait in the chair there, you'll be next.
Señor Coronado Medina, pase, y señor Leyva, usted estará, pasará después.
Mr. Coronado, please come in. I don't know if you can hear. Come into the courtroom. We need to get the
Señor
headphones.
Coronado, pase a la sala.
Okay. Are you able to hear on the headphones?
Sí.
Yes.
All right, Mr. Leyva Garcia, will you please go sit in the chair where Mr. Coronado just was sitting? He's got a black t-shirt with a beard. Okay. Oh, I can't see. All right. Hi, sir. Can I have your full name and your date of birth?
Jesús Arnulfo Coronado Medina, 88, el 5 de abril.
Jesús Arnulfo Coronado Medina, April 5th, 1988. Maria Corp, Court Interpreter's Office.
All right, thank you. You have been arrested on the following allegations: possession of dangerous drugs for sale and transportation of dangerous drugs for sale. Those are both Class 2 felonies. Conspiracy to commit those offenses, that's a Class 2 felony. Possession of dangerous drugs, a Class 4 felony. Possession or use of a weapon during the commission of a drug trafficking offense, that's a Class 4 felony. Using a building for the purposes of drug sales or manufacturing, that's a Class 4 felony. And possession of drug paraphernalia, which is a Class 6 felony. There is probable cause for all of those crimes, and I am appointing a lawyer to represent you in this case. Your next court date will be a status conference on Thursday, May 21st at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be May 26th at 8:30 in the same court, and that address will be on your paperwork. Bond is set in your case in the amount of $50,000. It is cash only. If you deposit that with the court, you will be released while you wait for your trial in this case. You have other conditions you're ordered to comply with, which include no contact with any arresting officers nor any co-defendants, no weapons, no drugs without a valid prescription, no alcohol. You may not leave the state without the court's permission. Everything I just told you is on your paperwork. If you please step to your left, the officer is going to give you a copy. Thank you. All right, Mr. Leiva.
Señor Leiva, pase al juzgado.
And then Mr. Barraza Rubio, will you please go to the chair?
Señor Barraza, pase a la silla.
Hello, sir. May I have your full name and your date of birth?
Miento.
José Saúl Leiva García, 13 de agosto de 1999.
José Saúl Leiva García, August 13, 1999, Maria Court, Court Interpreter's Office.
All right, thank you. Sir, you are arrested on the following allegations, which are possession of narcotic drugs for sale, a Class 2 felony, money laundering in the second degree, which is a Class 3 felony, possession of a weapon by a prohibited person, and possession of a weapon during the commission of a drug trafficking crime. Those are both Class 4 felonies. There is probable cause for all of those crimes, and I am appointing a lawyer to represent you in this case. Your next court date will be a status conference, May 21st at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be May 26th at 8:30 in the same court. Your bond in this case is $100,000. It is cash only. If you deposit that with the court, you will be released while you wait for your trial in this case. You have other release conditions you are ordered to comply with, which include that you may not possess any weapons, no drugs without a valid prescription, no driving without a valid driver's license. Everything I just told you is on your paperwork. If you step to your left, they'll give you copies. Thank you. Mr. Barraza?
Señor Barraza, pase.
Corey McGarry, if you go to the chair, please. Hello, sir. Can I have your full name and your date of birth, please?
Javier Alejandro Barraza Rubio, 31 de enero del 2000.
Javier Alejandro Barraza Rubio, January 31st, 2000, Maria Court, Court Interpreter's Office.
All right, thank you. You have been arrested for simple possession of narcotic drugs. That is a Class 4 felony. There is probable cause for it, and I am appointing a lawyer to represent you in your case. You have 2 court dates coming up. They will be in about 2 weeks. The first one is a status conference on May 29th at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be June 2nd at 8:30 in the same court. You qualify for release on your own recognizance. That means you will be released today. You are ordered to come to court and comply with all of your written conditions. That includes no weapons, no drugs without a valid prescription. Everything you need to know is on your paperwork. So don't lose it. Don't miss your court date. Okay? If you step to your left, they have that for you. Thank you.
Your Honor, would you like me to make an announcement just in case or not anymore?
I would. No, I definitely would. Thank you so much.
Yes, of course. ¿Hay alguien más que necesite intérprete en español? Levanten la mano si hay alguien más que necesite español.
And can you tell them, raise your hand where the court can see you?
Levanten la mano para poder verlo si la están levantando.
Okay, thank you so much. Because we can't see the back half of the room. All right, thank you. I appreciate it. Have a great day.
Thank you, Your Honor.
Okay, thank you. I appreciate it. All right, sir, can I have your full name and your date of birth?
Corian McGarry, 11/22/93.
Okay, and then the appearance of counsel, please.
Thank you, Your Honor. State, Burke on behalf of the state.
All right, Mr. McGarry, you just need to keep eyes front, please, just because of the security situation in the courtroom. It's very tight in there. We just want everybody eyes front.
Yes,
so
Your Honor.
So that helps the DOs too. Okay, and counsel, before I go on to PC, I'm seeing, okay, so the point of the report you attached was the drug test, the test on the drugs?
It does. It indicates in there that
Okay.
the methamphetamine did test positive as methamphetamine using a TrueNarc device. Additionally, in the narrative, there's information that the stolen motorcycle is being operated with a jiggle key.
Which is a tool?
Yes.
Okay,
So
thank you.
And then I did also provide a second affidavit from the controlled substance officer that indicates that the suspected fentanyl also tested positive.
The fentanyl, oh, okay, hold on, let me see that. Helps just because it's kind of long. Okay, let's see.
The language used is a little confusing because he says that that the instrument was inconclusive, and then he says it tested positive. It's a little strange, Your Honor, but.
Okay. Yeah, no, I agree. But, I mean, he's got two sentences. I feel, so there might have been two tests. You know, the field test might have been like a drippy one or something. So he says, I field tested the white powder, which tested inconclusive, using the TrueNarc instrument. Then he said, the TrueNarc result was fentanyl. So, then he says another one, he says, same thing, and the TrueNarc result was 3-fluoromethoxyacetyl fentanyl. So, I think that's sufficient for probable cause. Okay.
And then, and just in case the court had some concern about the sales portion of the narcotics, there's very detailed description in the in the narrative of the report regarding the hand-to-hand transactions that law enforcement said that they had viewed.
Okay, give me 1 second to look at that.
And I apologize for the lateness.
That's okay. And I mean, no, you have credit, I guess, I'm saying, you know. So, Mr. McGarry, just so you know, it's the state can come in and provide some supplemental information to what the police had put in. And so, and sometimes they don't get the reports right away, et cetera. So the state did submit something, and all of this is going to be available to you through your lawyer. It's just some of the preliminary police reports. Give me 1 second. Okay, I found it. All right, that's PC. Okay. All right, so Mr. McGarry, give me a second because we are going to have to, we do have to reprint Mr. McGarry's. All right, Mr. McGarry, you're here on new charges, also a probation hold. In your new case, you were arrested for narcotic drug possession for sale, a Class 2 felony, simple possession of dangerous drugs, a Class 4 felony, possession of a weapon by a prohibited person, and in connection with drug trafficking offenses, and so those are both Class 4 felonies. Possession of burglary tools, a Class 6 felony, and theft of a means of transportation, which is a Class 3 felony. Based on the totality of what the state presented, there is probable cause for all of those crimes, and I am appointing a lawyer to represent you. Your next court dates in this case will be a status conference, May 21st at 8:30 in the morning, with a preliminary hearing May 26th at 8:30 in the same court. And before And, well, you're also here on a probation case. I don't know if you want to be heard on that, counsel, but Mr. McGarry, the probation department will be filing a petition to revoke your probation based on the new arrest. So you'll go to probation court on May 21st at 8:30 in the morning. I think I can put those together. Yeah, same day, May 21st at 8:30 in the morning for both cases. But in the probation case, it'll be what's called a revocation arraignment hearing and a possible disposition hearing. So in the probation case, I do find that you will, in all reasonable probability, be revoked to prison in that case, so you don't have bail at all in the probation case today. Did the state want to be heard on the bond for the new case?
I have nothing to add to my written recommendation.
Okay, all right, and so Mr. McGarry, considering what's been alleged against you, your status on probation and your lengthy criminal history, I believe the same bond for you is appropriate that I gave the other people on today's calendar for the drug trafficking cases, and that is $50,000. It is cash only. If you posted that, though, you still have the no bond issue in your probation case. So you should probably talk to your lawyer before you look into posting any bond to make sure you're able to get out on everything. Everything I just told you is on your paperwork. If you step to your left, they're going to give you copies. Thank you. All right, then Ms. Bates, Sunshine Bates. And then, are you staying in counsel, or did you want a chance to get out the door? Up to you.
Yes, I'll be excused.
Okay, just stay right there for 1 second, ma'am. We're going to let her, if you want to, I mean, you can always come back if you want. All right. We do? For which one? We got a virtual?
She's at the bottom right-hand side.
Okay, let me see.
She's like the fourth one.
Oh, I can bump that up. Are you going to appear? Do you want to just do virtual? Up to you. I don't care. Whatever. You can do whatever you want. You can always attend. Whatever. They're waiting for what? The NOA?
The NOA.
Okay, and then they're going to send him the stuff. Okay, well, I'll probably try to do him towards the top of the, Okay, it's probably like 6, 8 people till I get there. Okay, all righty. Sorry, Ms. Bates, you can go ahead and come up to the podium, please. And then Caleb Baraka, if you'll go to the chair. Hello, ma'am. Can I have your full name and your date of birth?
Sunshine Bates, March 26, 2005.
Okay, thanks. You're here on a new case and on a bench warrant for another felony case, also a warrant from Peoria City Court. So let's start with the new charges from yesterday. It's just one charge. The allegation is narcotic drug possession, a class 4 felony. There is probable cause for it, and I am appointing a lawyer for you in this case. It's going to end up being the same lawyer that you have for your older case. Your older case is number 20 on the calendar, where you've already been charged with narcotic drug possession, a class 4 felony, and criminal trespass in the 3rd degree, a class 3 misdemeanor. You failed to appear at a status conference on February 6th, and a warrant went out for your arrest. So I'm going to give you the same next 2 court dates for those 2 cases. It's a status conference May 21st at 8:30 in the morning, and a preliminary hearing May 26th at 8:30 in the same court. Now, in the new case only, because you've come in with probable cause for any new felony, while you have any pending felony case, I must hold you for a bail hearing. I cannot give you bail today. So you're held no bond in the new case pending the outcome of a bail eligibility hearing. That will be held as an evidentiary hearing 1 week from today, which is May 22nd at 1:30 in the afternoon. So on your paperwork, if you're wondering when your bail hearing is, it's the one called evidentiary hearing on your paperwork. The purpose of that is bail eligibility. Your lawyer can tell you more about that on May 21st. Your bail hearing is on May 22nd. So you do not have bail at all today in your new case. In your older case, I'm going to affirm the bond set by the judge who issued that warrant for you. It is $500 secured plus written release conditions. Shouldn't try to post that, though, unless you're sure you're going to get out in all of your cases. All right, finally, you're hearing a warrant from Peoria City Court in a shoplifting case. It is a class 1 misdemeanor. This warrant went out April 9th of 2026. So you will be going to the Peoria City Court May 19th, which is Tuesday, May 19th at 9 in the morning. And your bond in that case, I'm going to set what we call a placeholder bond. It's $50 secured. It's meant to make you eligible for credit for time in custody and to ensure that the sheriff's office will take you to Peoria on the 19th so you don't catch a warrant. I otherwise probably would have released you in the shoplifting case, but you've got a couple felony problems.
Wait, shoplifting?
Uh-huh. Yep. So you'll go on the 19th, you'll get discovery, you'll get all that. If that rings no bells at all, the sheriffs are going to take you over on the 19th. You'll get discovery. I appointed a lawyer for purposes of the bond issue only. In the city cases, they'll make a decision if they're going to give you a lawyer for the whole case. I think they typically don't in misdemeanor shoplift, but you can talk to that court on the 19th about it. You may end up having to represent yourself or hire a lawyer at your own expense. That's just a shoplifting case, though. I did give you a lawyer for the felony cases.
Okay. It's my same attorney?
No, it won't be the same person. No, the cities can't use the county public defender.
Oh, okay. Is there any way that I could get my attorney's phone number from my last
We should be giving you, hopefully you have a yellow sheet. Officer, will you just look, does she have the yellow sheet with the, yeah. So there's public defender info in that packet of paper that they're going to give you.
That's the same one that,
no, it'll just be the main line, but they can connect you, and if you don't know that person's name, they can even look you up. Yeah, just call the main number for the PD. All right, if you'll step to your left, they'll give you that paperwork. Thank you.
So I'm not being released?
Correct. Because you came in with a new felony charge while you have a pending felony. That will happen to every person in this courtroom who gets released on a felony. You come in on a new felony, and the Arizona Constitution says you're not entitled to bail. What you do get is a bail eligibility hearing. There's a legal standard. Talk to your lawyer. So you could possibly get bail next week. You may or may not get bail on May 22nd. By law, you do not get bail today. Everybody who comes in with a new felony while they have a pending felony gets held no bond for at least a week, maybe the entire case. So talk to your lawyer. That's the whole point of the bail eligibility hearing. So they'll tell you on the 21st what's going to happen the next day. You will not be released between now and then. If you'll step to your left, I'll give you that paperwork. All right, Mr. Baraka? And then Jacob Burnett, will you go to the chair? Good morning, sir. Can I have your full name and your date of birth?
My name is Caleb Baraka. I was born on October 8, 2006.
Okay, thank you. You're here on a new case. You were booked in for one allegation of discharging a firearm at a residence. It's a Class 2 felony. 8 allegations of aggravated assault against minors. Those are Class 2 felonies. 2 allegations of aggravated assault against adults. Those are Class 3 felonies. 1 allegation of discharging a firearm in the city limits, and that's a Class 6 felony. There is probable cause for all of those crimes, and I am appointing a lawyer to represent you in this case. Your next court date will be May 21st at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be May 26th in the same court. All that information is on your paperwork. And in this case, bond is set in the amount of $100,000. It is secured. If you bond out, you will be on an ankle monitor under the supervision of pretrial services. The point of the ankle monitor is to keep you away from the alleged victims and the scene of the alleged crime. You may not go to that scene. No contact with any victims, witnesses, arresting officers. No contact with your co-defendants, Mr. Mugisha and Mr. Iloko. No contact with them. No weapons, no drugs, no alcohol. You may not leave the state of Arizona. Everything else is on your paperwork. If you'll step to your left, I'll give you a copy of that. Thank you. All right, Mr. Burnett.
Go to the front row left side. It's fine. It doesn't need any. Okay, she said it's fine.
What's that? Okay. All righty. After Mr. Burnett will be Baltasar Aguirre. All right, Mr. Burnett, can I have your full name and date of birth, please?
Jacob Albert Burnett, September 10th, 1983.
Okay, thank you. You're here on a new case. You're arrested for 1 allegation of aggravated assault with a deadly weapon or dangerous instrument. It's a Class 3 felony. Possession of a weapon by a prohibited person, a Class 4 felony. Disorderly conduct with a weapon, which is a Class 6 felony. And disorderly conduct by fighting, which is a Class 1 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer for you. I'm scheduling your next 2 court dates. The first one will be a status conference May 21st at 8:30 in the morning, which is this Thursday. Your preliminary hearing will be Tuesday, May 26th at 8:30 in the morning. All of that information will be on your paperwork. Your bond is $50,000. It is secured. If you bond out, you must comply with all of your written release conditions. You may not go to the scene of the alleged crimes. Absolutely no contact with the alleged victims, nor any witnesses or arresting officers. No weapons, no drugs without a prescription, no alcohol. Everything you need to know is on your paperwork. If you step to your left, I'll give you copies.
Good question.
Mhm.
Is there any way I can it could be any cheaper, because I got animals at home and nobody's there to take care of them?
No, sir. On
Okay.
these facts, with your criminal history, there appears to be a strong weight of evidence against you. I certainly recommend that you call animal control or someone else, because if those animals die,
I know.
it's a felony.
Yep.
And if you know that they are there alone and that they will die, animals will die of thirst within days.
I know.
You need to call you call animal welfare and tell them if you have nobody else who can get in there and get them for you.
All right.
Sounds like you're very well aware of that. I love animals, but that is not a legal basis to reduce someone's bond, particularly when they allege that this whole thing is on video and you have at least 5 priors. So if you'll step to your left, you get a copy of that paperwork.
All right, thank you.
Okay, thank you. And so I'm just going to do a couple more. 1, 2, 3, 4, 5, it looks like 6. And then we're going to get to Mr. Sanchez's case, but that's as fast as I can do it for today's purposes. Oh, and is 16 the one where they came and, oh yeah, they page 2'd him, that's right. And I said, no, I mean, they page 2'd him within like seconds before the calendar started. So I said, it'll be later. Mr. Aguirre, where is he? All right, thank you. And then Nicole Garcia, if you'll go to the chair. Hello, sir. Can I have your full name and date of birth?
Baltazar Carrillo, Gary Jr., 21492.
All right, thank you. Mr. Aguirre, you're here on a new case and 2 probation holds. In the new case, you were booked in for possession of dangerous and narcotic drugs. Those are class 4 felonies. Also shoplifting, alleged 2 different ways as class 1 misdemeanors. There is probable cause for all of those, and I am appointing a lawyer for you. I'm also appointing a lawyer in your probation cases. You're on probation in 2 different felony cases, and the probation department will be filing petitions to revoke your probation based on the new arrest. So you'll need a lawyer for those cases as well, and you'll have one. Your court date for everything, your next one is May 21st, which is this Thursday, 8:30 in the morning in the downtown Superior Court. Pardon me. The address is on your paperwork. And in the new case only, you'll also have a preliminary hearing May 26th at 8:30 in the same court. Now, I heard just minutes before, maybe like literally 2 minutes at the most before hitting the bench, that a police agency, I think it is this one, came and added some charges on you.
Yes.
They did not make it in front of me in time for me to see those. You will have to come back and see a different judge on those. They can't, we have too much going on, and that was vastly late for them to do it. So you're going to have to be held and brought back into court for a new charge.
There's no way of bond at work, like, you know?
No. So in each of your probation cases, you do have bond. In the older 2019 case, it's $1,500 secured. That's the ag DUI. In the new case, it's $1,000 secured. That's $2,500. In the brand new case, the new drug and shoplifting case, you have a $50 bond to make you eligible for credit for time in custody, because we would have released you in the absence of your probation cases and your criminal history, like if you didn't have all this criminal history. The new charges coming, I think at least some of them were possession for sale, so I think it may not even have been from yesterday. I don't know what the new charges are. I haven't seen them myself, so I'm just warning you, you have other new charges that have hit the jail. You have to be brought back and see a judge on those.
Will there be a bond for everything, or how's that work?
That's going to be a different case, and so it'll be up to the judge who sees you. It will not be me.
Everything as of right now has a bond, correct?
Right, yeah, $2,550 as of right now. I don't know what those.
That's whatever else they give me.
Correct.
Yeah.
Correct, yes. Try to be patient. It may take a few hours to get you on a calendar for those. I hate when the police department does that, but they can. Nothing prevents them from doing it.
Yeah, they should have just done it.
In any event, if you step to your left, that'll just take care of this.
All right, appreciate you.
Thank you. Okay, then we have, hold on, my system just went really slow. Okay, then I need, all right, Ms. Garcia, and then Angelica Niehaus, if you go to the chair. Hello, ma'am, can I have your full name and date of birth?
Nicole Garcia, 3/27/2001.
Okay, thanks. You're on a new case. You got arrested for possession of dangerous drugs for sale and transportation of dangerous drugs for purposes of sale. Those are both Class 2 felonies. Also, conspiracy to commit those crimes, that's a Class 2 felony. Also, possession of dangerous drugs, possession of a weapon during the commission of a drug trafficking crime, and using a building for the purpose of drug sales or manufacturing. All three of those are Class 4 felonies. Finally, possession of drug paraphernalia, which is a Class 6 felony. So I do find probable cause for all of those crimes, and I am appointing a lawyer to represent you. Your next court date will be a status conference May 21st at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be May 26th at 8:30 in the same court. Your bond is $10,000. It is cash only. If you post it, you must comply with all of your written conditions, which include no contact with the arresting officers or any co-defendants, no weapons, no drugs without valid prescription. Do not leave the state without the court's permission. Everything's on your paperwork. If you step to your left, I'll give you copies. Thank you.
Thank you.
All right, Ms. Niehaus? And then Haley Hartman, we go to the chair. Hello, ma'am. May I have your full name and date of birth?
Angelica Rose Niehaus, 9/12/92.
All right, thank you. You are here on a probation violation warrant. Let's see, in one case, and then I think the other case is an open case. Right, so you have one pending case that you caught a warrant in and one probation case. I'm going to start with the pending case, which is number 5 on the calendar. You have been charged with narcotic drug possession Class 4 felony and drug paraphernalia possession Class 6 felony. You already have a lawyer in this case. And so I'm going to send you for a status conference May 21st, which is this Thursday at 8:30 in the morning in the downtown Superior Court. I'm going to affirm the bond that judge set, which is $500 secured with written release conditions. That'll be on your paperwork. Now, in the meantime, there was a petition to revoke your probation filed. That was on March 26th. The petition alleges that you violated terms 3 and 5 of your probation. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. You're going to end up with the same lawyer for both cases. So your next court date in probation court, oh good, I can put it together with the other one. It'll be a revocation, arraignment, and possible disposition hearing this Thursday, May 21st at 8:30 in the morning. Now, in the probation case, I'll note that this issued as a no bond warrant, but looking at your case, your case appears to still be a Proposition 200 second strike. So I'm going to err on the side of caution and give you a bond because I think that may have been an oversight on the part of the judge who issued the warrant. So I believe you are entitled to bail in this case. So I am setting bond in the amount of $1,000 secured with written release conditions. So that makes your total bond $1,500. If you do post it, don't miss your court dates. Call your PO within 72 hours of release. Okay, if you step to your left, you're going to get a copy of that. Thank you, ma'am. Ms. Hartley, and then Thomas Robinson, will you go to the chair? Hello, ma'am. May I have your full name and your date of birth?
Haley Hartman, 02/25/2005.
All right, thank you. You are here on a warrant for failing to appear in a pending case. It was a status conference on May 14th, so yesterday. And, well, that's when the warrant went out. And so I'm going to give you a status conference May 21st at 8:30 in the morning, downtown Superior Court, preliminary hearing May 26th at 8:30 in the same court. You've been charged in this case with dangerous drug possession, a Class 4 felony, and drug paraphernalia, a Class 6 felony. You already have a lawyer, so you will still have one next week. And I'm going to affirm the bond set by that court, which is $500 secured with written release conditions. If you bond out, comply with all of those. Do not miss any court dates, or you could lose that bond money, and there will be another warrant issued for your arrest. If you step to your left, she's going to give you your paperwork. Good luck, ma'am. Mr. Robinson? And then Mario Sebastian, will you please go to the chair? Hi, sir. May I have your full name and date of birth?
Thomas Daniel Robinson, March 4th, 1986.
Okay, thank you. Mr. Robinson, you are here on 2 probation cases and a new felony arrest. I'm going to start with your probation cases. That's numbers 12 and 14 on the calendar. You're on probation in 2 separate cases, and there were petitions to revoke your probation filed in both cases back on October 23rd of last year. Those petitions allege that you violated terms 3, 4, 5, and 7. You'll get copies of them from your lawyer, and I am appointing a lawyer for you in probation court. Your next court date there for both cases will be Thursday, May 21st at 8:30 in the morning. That's this Thursday in the downtown probation court. That'll be a revocation, arraignment, and possible disposition hearing in both cases. And in both cases, in each case, you have a $250 secured appearance bond. That is $500 total, and written release conditions that I'll let you read for yourself. Just don't forget to call your PO within 72 hours of release if you do post the bond. If you don't post the bond, then don't worry, you'll see your PO next week. All right. Oh, I forgot your new case, sorry. In your new case, you got booked in for drug paraphernalia possession, class 6 felony. I'm gonna give you a lawyer and 2 different court dates that are gonna be later. So in the new case, you'll have a status conference on May 29th, which is 2 weeks from today, and a preliminary hearing June 2nd at 8:30. And in that case, you do not have any additional bond because I did not find probable cause. So you can talk to your lawyer about this, but it's not dismissed. I just can't give you any bond, but you do get a lawyer and you do get court dates because it's not dismissed. But you'll see your lawyer in probation court on the 21st. Feel free to ask that person about how this works. I think they can give you some more information on it. But in any event, if and when you're out of custody, you should go May 29th at 8:30 in the morning. Okay, if you step to your left, I'll give you that paperwork. Good luck, sir. All right, then let's do Mario Sebastian, and then we'll be ready with Mr. Sanchez's case for counsel online. All right, so Mr. Sanchez, if you go to the chair, Mr. Raymond Sanchez. Hello, sir. May I have your full name and your date of birth?
Mario David Morales Sebastian, January 16, 2007.
Okay, thanks. Mr. Sebastian, you're here on a new case and a warrant from Buckeye City Court. In the new case, you got arrested for, it's criminal trespass in the first degree, which is a class 6 felony. I'm not going to reprint for this. It says it's class 5 felony on your paperwork, but it's always and only a class 6 felony. It's criminal trespass. Also, criminal damage, a class 2 misdemeanor, and obstruction of justice by the refusal to provide a true name. There is probable cause for all of those, and I am appointing a lawyer to represent you. Your next court date will be a status conference May 21st, 8:30 in the morning. That's this Thursday in the Downtown Superior Court, with a preliminary hearing May 26th at 8:30 in the same court. You have a $500 secured appearance bond and written release conditions in this case. That includes not going to the scene of the alleged crimes, no contact with the alleged victims or witnesses, no weapons, no drugs, no alcohol. In the Buckeye case, it is a failure to appear warrant in a shoplifting case. The warrant was issued April 13th of 2026. This is a class 1 misdemeanor. They've also added the misdemeanor allegation of failing to appear in a misdemeanor case, which is itself a class 2 misdemeanor. So I'm going to give you a court date in Buckeye, which is an arraignment hearing May 20th at 1 in the afternoon. That's this coming Wednesday in the Buckeye City Court. And I'm going to give you what we call a placeholder bond in that case. It's $50 secured. It's to make you eligible for credit for time in custody and to ensure that our sheriff's office will take you over to Buckeye City Court for that hearing if you are not able to post a bond in the new felony case. So your total bond is $550 for both cases. You have court dates for everything on your paperwork. If you'll step to your left, I'll give you those copies. Thank you. All right, and then Mr. Sanchez, after that, Bernard Myers, will you please come to the chair or go to the chair? Let me get my camera on, hold on. I did not, does it look like I did? No. Okay, let's just be sure. Okay, here comes my camera. Okay, great. And it looks like we don't have the monitor working. I'm sorry, Mr. Sanchez. Usually we can get the video for you up here so you can see your lawyer. You'll be able to hear her and I can see her. Okay. All righty. So this is Mr. Sanchez 20. All right, so let's start with your full name and date of birth, please.
Raymond Sanchez, May 11, 99.
Okay, thank you. And then the appearance of the state.
Brooke Dawn on behalf of the state.
All right, and the defense, please.
Good morning, Judge. Melanie LeBoy appearing on behalf of Mr. Sanchez. Judge, I'm appearing for this hearing only.
Oh, okay, thank you. All right, Mr. Sanchez, you've been arrested on new allegations. They are aggravated assault on a first responder, which is now a class 4 felony under Arizona law. We still get police booking that as class 5s all the time, but the law has changed. It's a class 4 at least. So also obstructing a public roadway, which is a class 2 misdemeanor. Before I turn to release conditions, counsel, did you want to be heard on probable cause?
Judge, I don't have any arguments regarding probable cause.
All right, so I'm going to let the state know that on these facts, this court I'm not persuaded that it was a reasonable apprehension of physical injury. So did you want to be heard on that? Because the court is not inclined to find probable cause on the aggravated assault.
I did, Your Honor, and
Okay.
I provided, and again, I apologize for
Oh.
the lateness, but I think court staff sent to Ms. LaBoy. I did provide 2 documents to provide
Okay.
some additional information.
Okay, so let me just ask, so Counsel LaBoy, have you had a chance to read these? I'm going to have to sit here and read them. We'll get them over to you. I mean,
Judge,
I'll make
it looks like I just got them, so I need to take a look at them.
Okay, let's sit and read. Sorry, Mr. Sanchez, you can just stand there. We're going to read the additional stuff, okay? Okay, well, counsel, I still am not inclined to find probable cause. Did you want to argue?
Yes, Judge,
yes.
oh, I'm sorry.
Okay, so yeah, if you want to raise the argument, let me let the defense go first, or actually, well, no, I apologize. It is the state's burden, so normally I'm in the position of saying I am inclined to find probable cause based on what the police submitted. So I sort of skipped the state, but it is the state's burden. So let me let the state go first, and then you can rebut Ms. LaBoy, and I'll make a decision. Go ahead, Ms.
Thank you, Your Honor. It appears that when law enforcement initially made contact with Mr. Sanchez, they were going to assist him, I think, in charging his phone, which is the request that he made at that time. He indicated he was waiting for an Uber, and I think there was a little bit that came before that, but I don't think that's really relevant for our discussion. Today, he was being aggressive and yelling at the officers and using profanity. They were trying to assist him. He started to walk away and said, quote, "You're lucky I don't beat the fuck out of you." And so the 2 officers that were there in 2 separate patrol vehicles indicated that they were just going to leave, given the Mr. Sanchez's aggression towards them, and that there was not a crime that had been committed or was occurring at that time. When the one officer got into the patrol vehicle and was attempting to get out of the parking lot or the area where they were, Mr. Sanchez not only was in front, but was literally right up against the front push bar of the patrol vehicle and was yelling at the officer. The officer repeatedly told him to get away, to get out of the way so that the officer could leave. The officer indicates that Mr. Sanchez started asking the officer to hit them with the vehicle. The officer then reversed approximately 20 feet back to create more distance, and Mr. Sanchez walked to the front of the vehicle again and was standing in front of the push bar of the vehicle. At that point, law enforcement, the officer indicated that he said that he would, quote, "kill me in a 1v1, meaning a one-on-one situation. The officer believed that if they were to exit the vehicle to have Mr. Sanchez get out of the way so they could leave, that there would be a physical fight. Additionally, they indicated that that he had been rolling up his sleeves and kind of the motions that people make when they're about to fight, or I think they call those pre-attack indicators in the law enforcement lingo. So the officer did believe that if they that there would be a fight with Mr. Sanchez, and I do think that that those actions, especially in following them after the officer tried to back up and create distance, did put the officer in reasonable apprehension of imminent physical injury, Your Honor.
Okay, thank you. Ms. LeBoy.
Thank you. Judge, I completely disagree. The officer was in a 4,000-pound vehicle and my client was standing there unarmed, and in no way threatening to someone in a vehicle of that nature. There were no officers out there. They're just in their vehicles. You know, if anything, maybe my client, you know, was speaking in a manner that was upsetting to the officers, but in no way was he doing anything to commit aggravated assault. I would assume that if he was being difficult, he would have also been charged with resisting arrest once they tried to arrest him, but it literally says he was taken into custody with no further incident, which just goes to show that he was of no threat to the officers. Thank you, Judge.
All right, Mr. Sanchez, I've read what's been alleged against you both in the booking paperwork and the supplemental police reports, and I've listened to the arguments of counsel. I still do not find probable cause for this because an aggravated assault takes a baseline assault, and the baseline assault in your case would have to be placing someone else in reasonable apprehension of imminent physical injury. And I find that on these facts currently, the allegations fail on the point of reasonable and imminent. I believe it definitely lays out probable cause for misdemeanor threatening and intimidating and misdemeanor failure to obey a police officer in a traffic situation. Definitely. They didn't book you for those, though. And certainly, if they've got the body camera footage that they likely have, it may support their allegation that you were wildly drunk and incredibly obnoxious. I don't know. But as far as the idea that if the cop, you know, had chosen to get out of the vehicle at that moment, you would have assaulted him. That I'm not even disagreeing with the cop's belief if you know that it was likely. But in fact, then they do go on to describe that some other cops came up and arrested you without an incident. So probable cause is a low standard, and I find this does not meet it. So doesn't mean it's dismissed though. So please talk to your lawyer. The state can absolutely choose to go forward on this with formal charges. So what it means for me is I disregard it essentially in the setting of release conditions. So I do find probable cause. Counsel, did you want to be heard on obstructing the public roadway? Because I definitely plan to find probable cause on that.
Judge, no.
Okay. All right. So for purposes of this hearing only, Mr. Sanchez, I don't find probable cause for the aggravated assault. I do find probable cause for the second-degree misdemeanor of obstructing a public roadway. So I'm not appointing a lawyer for you. You can hire a lawyer of your choosing, or you could fill out indigency paperwork at a future hearing and try to qualify for a court-appointed lawyer. I'm just not appointing one for you today. All righty. I'm going to give you a. Oh, did you want to be heard on release conditions, counsel?
No.
Okay. So I'm intending to give you a status conference of May 29th at 8:30 in the morning in the downtown Superior Court. That's 2 weeks from today. Preliminary hearing June 2nd at 8:30 in the same court. And so, Counsel LeBoy, I know your client has been living in Illinois. What can you tell me about his current situation, you know, and ability to appear for future hearings?
Judge, obviously his family hired us. In this instance, I was not able to talk to my client. But obviously, I don't see any reason if he has family who's supporting him that he would not be able to come back for a court hearing.
All right, and this is I'm cognizant that I only found probable cause for a misdemeanor. So, counsel, did you want to be heard on that?
No. Well, I do briefly.
Okay, go ahead.
As the court has indicated, it's a misdemeanor. I don't think that the only criminal history that I believe Mr. Sanchez has is a prior misdemeanor. I don't believe he has any felony convictions and no prior crimes of violence. So given all of that, the state would not object to him being able to leave and come back to appear for court.
Okay. All right. So give me 1 second. What's today? Okay. And so, so counsel, your client would be intending to go back to Illinois, as far as you know. And if
far
you
as I
feel
know.
like asking him and you don't mind, you're welcome
Yes,
to. Okay, go ahead.
Mr. Sanchez, are you going to be returning back to Chicago pending release?
Yes,
Are you going to fly?
fly, yeah. And I start a new job on the 1st of June.
Okay. Didn't save my work anyway. Okay, hold on 1 second.
And Mr. Sanchez, just so you know, I'm going to update your family after we're done with this hearing, okay?
Okay. Yeah, no, I have.
Okay, let's see if it takes this time. Oh. Sorry, they've been doing alleged improvements to our system, although I strongly dispute the term improvement. Okay, let's see. Okay. 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 So, Mr. Sanchez, I'm going to release you on your own recognizance. Part of that is that you don't have much, if any, criminal history. Looks like you've got okay, you've got a public urination ticket out of Tempe, which frankly everybody who's been in the criminal justice system here forever pictures as drunk college student ticket, but you have a conviction for that, which certainly does suggest to this court that alcohol and you are having a bit of a problem together, and it has landed you here today. I'm absolutely ordering no alcohol. You need to stay off the sauce. If I believe 10% of what they're alleging against you, I pity the Uber driver. I pity the cops who were trying very hard not to arrest you. So, no alcohol. The case is pending. That's about it, though. Looks like that's literally it. So, I also presume you would not like to have a felony warrant out for you if they do charge you with a felony. So, all right, I'm going to release you on your own recognizance. I got to look at the, hang on, we have all these, okay. Sorry, all of the improvements to our system. If you check anything new, it will recheck do not leave the state. And they won't be fixing that for a long time, I bet. Okay. Here it says, you may travel to Illinois and any layover states in between. So if you have to take a connection in Detroit, you may. And our stupid system won't allow me to make your departure date today. So were you planning to fly out later today? Good. Then so it'll say leave on or after tomorrow, return by May 29th. Now, talk to your lawyer. You can get continuances. You can, possibly get the court date moved. Your lawyer can keep track of it to see if the county attorney does go forward on a felony, because it's up to them now. They have a window of time to decide what, if any, formal charges they may file against you. And even if they didn't go forward on a felony, they're free to go forward on misdemeanors. It's really in their hands right now. So you need to keep in touch with your lawyer, keep in touch with the court about your whereabouts. This is just a booking decision. It has to do with release conditions. So this is not a charging decision in your case. That will be made by the prosecutor's office later. They now get a longer window of time to do it. Okay. Anything else from the state?
No, Your Honor.
All right, and from the defense?
No, Judge, thank you. And again, Mr. Sanchez, I will be updating your family, and please call me when you get out.
Okay.
Okay.
Thank you.
All right. Then have a great day, ma'am. You're welcome to disconnect. If you'll step that way, they'll give you the paperwork, and we'll email it to you, counsel.
Thank you.
Okay, thank you. Have a great day. And did you want to? Yes. Okay. Excellent. All right, then Mr. Myers, Bernard Myers, and then Joseph Finnegan. We go to the chair, please. Hello, sir. Can I have your full name and your date of birth?
No, Myers, 4/12/67.
Okay, thank you. You're here on a new case. You got arrested for possessing dangerous drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. Your next court date is going to be in 2 weeks. It's a status conference, May 29th at 8:30 in the morning. The address in downtown Phoenix for the courthouse will be on your paperwork. Your preliminary hearing will be June 2nd at 8:30. And you qualify for release to pretrial services in this type of case. I do know that you have some criminal history, but on a new drug charge, I'm willing to let you come to court on your own or not. If you don't, there will be a warrant issued. You know how that goes.
Yeah.
Everything's on your paperwork. If you'll please step to your left, she'll give you a copy. Thank you. All right, Mr. Finnegan, Joseph Finnegan, and then Kimberly Trotter. Will you go to the chair? Hi, sir. Can I have your full name and date of birth?
Joseph Finnegan, 8374.
Okay, thank you. You're here on a new case. You got arrested for possessing dangerous drugs, a class 4 felony, and drug paraphernalia, a class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. You have 2 upcoming court dates. The first is a status conference, May 29th at 8:30, which is 2 weeks from today. And your preliminary hearing will be the following Tuesday, June 2nd, 8:30 in the morning. The court address in downtown Phoenix is on your paperwork. And looks like you qualify for release on your own recognizance. I'm not showing any felony convictions for you. So just go to court, comply with release conditions, and all will be well. If you miss a court date, though, you're going to catch a warrant. All right,
Okay.
she's got your paperwork for you. Thank you. Thanks. Ms. Trotter? And then Mary Jane Gonzalez, we go to the chair. Good morning, ma'am. Can I have your full name and date of birth?
Kimberly Dawn Trotter, 591980.
Okay, thank you. You're here on a new case. You got arrested for dangerous drug possession, a class 4 felony, organized retail theft, which includes using a device to facilitate shoplifting, and in this case, the allegation is a purse, because a lot of people in your situation go organized.
Yeah.
It covers groups of people shoplifting together. It also covers using something to facilitate the shoplifting, and that's what they're accusing you of.
Okay.
And that is a class 4 felony. Also, drug paraphernalia possession, a class 6 felony. I am appointing a lawyer for you, and your lawyer can go over what you're charged with and what the elements are.
Okay.
So your status conference will be in 2 weeks. It's May 29th at 8:30 in the morning. Preliminary hearing June 2nd at 8:30 in the same court. That address is going to be on your paperwork, and you qualify for release on your own recognizance. You don't have any felony priors. This is a drug charge and what I view as aggravated shoplifting. So come to court. This is, all probation eligible. Don't miss court. The sympathy for missed court dates is low. It's not a doctor's appointment. I'm trying to tell you, because you haven't had a felony conviction, don't miss court.
Okay.
The one way to guarantee you'll spend more nights in jail is to miss court. Otherwise, you might not even do a single other night in jail besides last night. Even if you got convicted, you might not get another day of jail. But you'll guarantee you do if you don't go to court. All right.
I'll be there.
You step to your left, you get the paperwork. Don't go to that store, okay?
Yeah, I
Don't,
won't.
Okay, all right. Ms. Gonzalez, and then Justin Rose. We go to the chair. Hi, ma'am. Can I have your full name and your date of birth?
Yes, Your Honor. My name is Mary Jade Gonzalez, and my birthday is March 11th, 2003.
Okay, thanks. You're here on a warrant from the Kyrene Justice Court where you got charged in a citation with criminal speeding. It's a class 3 misdemeanor. Looks like the warrant went out December 22nd of 2025 after you failed to appear at your citation court date, which was December 9th. I'm going to give you a new one. It's an arraignment hearing in about 2.5 weeks. It's June 3rd, 9:30 in the morning in the Kyrene Justice Court. The address is on your paperwork. I'm releasing you on your own recognizance, which I typically do in this kind of case when people don't show up on a citation, because I figure you got a little punishment for not showing up. Assuming you did not like it, you'll probably go next time. This is the lowest class of crime on the books, but it is a crime. You need to go. And so if you're not there, you're going to end up with at least a small bond, even on a criminal speeding ticket. So
Okay.
just go, okay? It's all in your paperwork. If you step to your left, I'll give you a copy.
Thank you, Your Honor.
Mr. Rose, Justin Rose, and then Katie Rayling. Will you go to the chair? Hello, sir. Can I have your full name and date of birth?
Justin Stephen Rose, September the 14th, 92.
Okay, thanks. You're here on a warrant for the Agua Fria Justice Court. This is a post-conviction warrant for undoubtedly failing to pay fines and fees because it's driving on suspended, meaning I don't think they order classes or anything for that. It's just money, I'm sure. This warrant went out April 13th, 2026. I'm going to give you a court date in the Agua Fria Justice Court of June 3rd, so about 2.5 weeks from now at 10:30 in the morning. The address is on your paperwork. And I'm going to release you because when I looked at the records, what I could see is that this court released you about a year ago and you went. And it's not our job to get you to pay. That's their problem. Our job is to get you to go to court and comply with release conditions. So I'm trying to encourage you to do it again. Go, because that's what me and many of my colleagues, that's what we look at is, you know, you lost track of them. They were sending angry notes and it was coming back. So you got to keep your addresses updated with him if you want to avoid this.
Yeah.
But you went last time, so I have a good reason to think you'll go again. So even if you don't have the money, you've got to show up, and then at least you could argue to the next person in my position if they don't already know it. Some of us know how to look it up, some of us don't. So even if that person's like, I'm giving you a $700 cash bond, you could ask very politely and say, could you please look back in the court records? Because I always go when I get arrested, I just don't have money. And I know people don't have money because anybody who had the money would pay so that this didn't happen. Everybody who can afford to pay pays on this stuff so that this doesn't happen. So I'm positive you don't have money. You still have to go. And you did that last time, good job. This is the benefit you got from that. It only lasts up until they start sending you notes and you don't show up.
I just have a quick question.
Go ahead.
So behind all these issues with the driver suspended, I had a vehicle that I lost my vehicle with behind all this stuff, and it's made me homeless now. Is there anything that I can basically do to like get them to like understand that and
get
like
rid of
wait?
some of it?
I can't pay. That's
Well,
what I can do.
Go take this paperwork. I would at least ask them for one night of credit. It's up to the judge whether they give it to you, but say, can I get one credit for a night in custody, like a day of credit? I don't know if they'll knock off 50 or $100. But you need to talk to that justice of the peace. The law changes over time about what they're allowed to dismiss, what they're not. It's just my personal perception and not the views of the Superior Court that they should be given more leeway by the legislature to get rid of some of these. I firmly believe that. I see the consequences of it, that our state, many states, have a problem with squeezing people for this stuff that don't have money. But some of it is within their discretion and some of it is not. And I haven't worked in those courts in a long time, so I'm frankly not even sure which parts they could give ground on and which parts they don't. And some of it is very personal to that justice of the peace, whether they will or they won't. So all I can tell you is go and ask. Do the best you can. I wish you good luck with that because I see people arrested for a decade on this stuff to the point where it's absurd to think that that person has money. Why would you rather be arrested as an ugly surprise for a decade if you could just go give them $700? So go, sir. I wish you good luck. I hope it works out. The most I can do for you today is release you and reiterate that if you don't go, you're going to get at least a small bond. I might give like $50 on a case like this if I saw that we released you and you blew it off. So you could call if it's a bad date and you don't have transportation. Call before the warrant goes out. Call before the court date.
What was the date again?
Oh, it's going to be on your paperwork, but it is the June 3rd.
Okay.
So if you have any issue getting there, call them. They, in my experience, they will at least give you one continuance to try to get to court.
Okay.
And all I can tell you is good luck, sir.
Thank you, ma'am.
Except you'll have to get the paperwork. Ms. Riley and Katie Riley, and then Francisco Chavez, will you go to the chair? Hi, ma'am. Can I have your full name and your date of birth?
Katie Riley, July 30th, 1998.
Okay, thank you. You are here on a Justice Court warrant from North Valley Justice Court. This went out as an initial arrest warrant, and what that means is there was originally a summons. There's constables in the Justice Court. They went around and tried to find you and couldn't find you to serve you with the summons. So you have not missed any court dates in this case. It only turned into a warrant because they couldn't find you, and we don't hold that against you. So, but you have been charged with extreme DUI, alleged 2 different ways, and simple DUI. Well, no, one is simple DUI, which means impaired to the slightest degree. One is DUI with blood alcohol of 0.08 or more. Extreme DUI is blood alcohol of 0.15 to 0.20. Anyway, they are all class 1 misdemeanors. They all arise from what I'm sure must be the same incident on March 15th of 2025. And it looks like the agency that arrested you was DPS, but that's all I know from the warrant. You'll get police reports. You'll get a copy of the charges at your next court date, and I can give you a lawyer because you do face some potential for mandatory jail time. on a misdemeanor DUI. So I am appointing a lawyer for you. Your arraignment hearing will be June 2nd at 9 in the morning in the North Valley Justice Court. The address is on your paperwork. This is not a new case. You have not missed a court date. I'm going to release you on your own recognizance. Just show up. You see what happens if you don't show up.
Absolutely.
If there was any collision in the case, any property damage, there might be a victim for restitution purposes. So in your paperwork, if it says no contact with the alleged victim, that's what I mean. If there was no collision with anything, then there is no victim. So that doesn't apply. No drugs without a valid prescription, no alcohol as of today between now and whenever another judge gives you permission or your case ends, no driving without a valid license, okay? Sign your paperwork. If you step to your left, she'll give you that. Thank you. Mr. Chavez? And then Raven Salcedo, will you go to the chair? Hello, sir. Can I have your full name and your date of birth?
Francisco de Chavez, March 7, 1977.
Okay, thanks. You're here on a new case. You got booked in for possessing narcotic drugs, a class 4 felony. There is probable cause for it, and I am appointing a lawyer for you. I'm giving you 2 court dates. They're in 2 weeks. The first one is a status conference on May 29th. That's Friday, May 29th at 8:30 in the morning, and the preliminary hearing will be June 2nd, the following Tuesday, I believe, at 8:30 in the morning. And you do qualify for release on your own recognizance. I know you got arrested with some other folks during the execution of the search warrant, but they said you were just, living in your own separate trailer, doing your own separate thing. So you're not charged with any of that. I'm just, and you don't have, I don't think you have any felony priors. No. So you're released on your own recognizance. This is probation eligible. Don't miss court. You'll just catch a warrant for no reason.
Yeah, I will.
All right, everything's on your paperwork. If you step to your left, I'll give you that. Thank you.
you.
All right, Ms. Oseto, and then Mr. Worth, if you go to the chair. Thank you. Hi, ma'am. Can I have your full name and your date of birth?
Raven Nicole Safedo, 12/29/06.
Okay, thanks. You're on a new case. You got booked in for disorderly conduct by fighting. It's a class 1 misdemeanor, and there is probable cause for it. I'm not appointing a lawyer for you today. You always have the right to hire one, but the city court wants to make that decision on their own about court-appointed counsel, and it's my understanding they typically only give you counsel in this kind of case if the state is asking for jail time, which on these facts would surprise me, but it's up to the, Peoria City prosecutor. So I'm not appointing a lawyer today. You have the right to go hire a lawyer immediately after this hearing, or just go and represent yourself. Your arraignment hearing will be June 2nd, which I believe is a Tuesday, June 2nd, in the Peoria City Court. The address is on your paperwork. I am going to release you on your own recognizance. It appears that the alleged victims in your case include your grandmother and somebody who is a male.
My uncle.
I wasn't sure if it was like maybe a boyfriend or, okay. And so what I've decided to do is just do a no uninvited contact order, which I only do in cases where the person really doesn't have any criminal history. I'm not worried about them, meaning even if you did everything they accuse you of, I think you could still go there peacefully and if they're okay with it. So that's what uninvited contact means. Now, victim 2, your uncle, may be a lot less willing when I read it than your grandmother because they're alleging a bit of a kicking in the sensitive area and a face clawing, and he may be not very forgiving. But you can at least attempt to contact them and stay there. If one or both of them don't want you there, then you have to find another place to stay, or you're going to get arrested if the cops get called. That's what uninvited means. If say it's 3 days from now, everything seems okay, and there's another altercation, and one or both of them says get out. If you don't get out, the police are going to get called. You will be arrested for violating this order. So hopefully that makes sense. That one was borderline because of the uncle, but you don't. Let me double check that you don't have any criminal history.
I do have a question.
Go ahead.
Is the same thing going for him as well, or just me?
Oh, did he get arrested? I don't know. They didn't say that he did. And sometimes what the police do, sometimes what they do, is they will book one person into county court and one person into city court. I have no idea why. Or they'll give one person a citation and arrest the other person. So I can't say for sure that he was not arrested or given a citation. It doesn't look like it. It doesn't read like it. but he may not have been arrested. So certainly that's something you're allowed to call the Peoria Police Department and ask about and say, hey, I believe I'm the victim in a case with him. What's happening with that?
Would I call the non-emergency?
Yeah, I would call the non-emergency and say, I believe I was the victim of a crime, and I would like to talk to somebody about what is the status of that, because any person can call the police and say, I want to report a crime, and then you're entitled to know what they're doing about it. Like, they may say, we've decided to do nothing, but you are entitled to get an answer from them.
Yeah.
So always be polite, because, you know, the phone can always get hung up on you. So be polite and say, I just want to answer. You do have, you know, potentially victims' rights in that case, in any event. But that's kind of between you and the Peoria City Police right now.
Mm-hmm.
All right, but in this case, you are under these orders. Don't violate them, or you could end up right back here, okay?
Okay.
All right, everything's on your paperwork. If you step to your left, I'll give you copies. Thank you. All right, Mr. Worth, you can come in. Hello, sir. Can I have your full name and date of birth?
Anthony Healy Worth, June 6, 1992, excuse me.
Okay, thank you. No worries. You're here. It's June 6th? I have June 19th.
June 19th. I don't know what I just said.
Okay.
June 19th.
You were born on Juneteenth. Okay.
Yes.
All right. You are here on a warrant, pardon me, out of Wisconsin, as I recall, it's St. Louis County, Wisconsin. And it looks like you've been charged there
Missouri.
with...
Sorry.
Oh, is it Missouri?
Yeah.
Oh, it is Mo. Why did I think Wisconsin? Where in the world did I get that? Because I'm looking right at it. It says Mo. Okay. All righty. Oh, I know. It's because of another code, which is actually W1. I was looking at the wrong spot.
All right.
Okay. All righty. St. Louis County, Missouri, which makes more sense, but it could be a St. Louis County, Wisconsin. What do I know? And so Missouri says they want to extradite you on this warrant. So what you have is extradition rights in this case, which is very different than an in-state warrant. That's why we save you for last, because there's a lot of moving parts to these. So you have 4 basic rights in an extradition proceeding. This is not the criminal case. This court does not determine whether you did it. First, you have the right to have an extradition hearing within 90 days after today. Second, you have the right, as part of that whole extradition process, to insist that there be a governor's warrant signed by each of the two sitting governors before you can be taken back there. And that's part of why they get 90 days, because it takes a while to get sitting governors' signatures. You have the right to hire a lawyer at your own expense. You always have that right. I can't appoint one for you today because it isn't a criminal case. It's a civil extradition case. The criminal case is in Missouri. That's where you have the constitutional right to a lawyer. Finally, you do have the right to bail if you do not waive extradition. Waiving means agreeing to go back. If you don't agree to go back, which you don't have to do, then I am going to set bail in your case, and it is my intention to set bail in the amount of $25,000 secured with written release conditions. If you don't go back. Now, you could post that bond and be out of custody while the extradition proceedings are happening. You have to come to all of our court hearings, which is 2 or possibly 3 before your actual extradition hearing. If you miss one of our court hearings, we keep your bond money and we issue another warrant for your arrest right on top of the Missouri warrant. So you can also sidestep that whole process. I call that the 90-day path. If you're on the 90-day path, you're going to have an extradition hearing. They are working on those governor's warrants, and you do have a bond. If you want to bypass all of that and just agree to go back, you can do that. That'll start a 30-day clock running against them. But that clock doesn't start until you're done with any Arizona criminal cases. So it looks like you have a probation violation going on and a Phoenix case. You have a misdemeanor Phoenix case. So just so you're aware, if you did waive extradition today, I don't believe your 30-day clock would start tomorrow. Normally it starts the day after you waive. It would start the day after you're done with the last of any Arizona criminal cases. So I don't know how long those other ones are going to take to go through the system. Are you in probation violation proceedings already?
I'm not sure.
Okay.
I just want to ask, when I'm done, does that mean that when everything is completely finished?
Right, so that means like...
So I have to stay in jail until then?
Correct. And so it looks like you got a $250 bond on the probation violation. I saw that. That was early this morning. You got a $250 bond. And then you've got the Phoenix case, I doubt you've seen a Phoenix judge yet. You're probably on their 4 p.m. calendar here at the
I
jail.
seen him this morning.
You did?
Yeah.
Oh, what'd they do?
I have to pay a fine on June 26th, but by June 26th, I have to pay a $50 fine.
Okay, but it sounds like otherwise you're released.
Yeah.
Okay. Okay, so what's holding you in Arizona right now is the probation warrant. And it looks like your court date in probation court is in a week. Let me pull that up. Hang on, I just had it. From today's 2 a.m. calendar, and it says your next court date in probation court is, it's probably linked, but okay. May 21st, so this Thursday at 8:30 in the morning, you're going to probation court for the Arizona case. Some Arizona probation cases resolve on the same day, basically because you make a deal with the state. And so if that happened to you, if you waived today, and then you did take a deal or that probation got dismissed on Thursday, that would mean your waiver clock started on Friday, May 22nd. If you don't want to do that, you never have to waive. You never have to waive. You'll be back in court in front of our extradition judge on June 1st at 1:30 in the afternoon, which is about 2 weeks from now, June 1st at 8:30 in the morning.
So I want to make sure, so I don't have to be done with probation. I just have to have this.
The violation proceedings have to be over, and you're going to need, no, you don't need permission to leave the state, meaning if you're still in custody and Missouri comes and gets you, they're going to take you to Missouri. So your probation officer needs to be aware, so they help keep track of you, because it doesn't mean that you voluntarily left the state. It means you got dragged back there. But you need to stay in touch with your PO here to make sure you don't catch any warrants, that they know where you are, and that you're keeping in touch with them. But you can go get advice from your lawyer on the, you got to step back to the podium.
Oh,
sorry, it's okay. Not that I think you're going to rush the stage. It's just, then you're in the.
I know you're very informative. I just want to make sure. So the $50 fee, I don't got to pay it before I go to Missouri. I'm not going to pay $50. I'm not going to have that.
Right.
So basically, the day that they want to let me go from this jail, that's when Missouri has the clock.
That's when the clock would start. Is
Okay.
once Arizona said you no longer have any criminal charges or holds, their clock will start.
Okay.
And they'll have 30 calendar days to come and get you once the clock starts. That is the point of waiving, is you agreed to go back, so they can't drag their feet. They have 30 days to do it. But you're held no bond. If you waive, you don't get bail. There's not even the option of bonding out until they've had 30 days to come and get you. So you would convert to no bond right now if you waive, if you give up your rights.
I couldn't bond out for $2, so I'm good. I'm all right with that.
Okay. All right. Then let me ask you some questions, because I have to make a record that you understand the rights you have before I ask if you want to give them up.
So my probation does not have to be over before I go. So I won't have to sit here for a year of probation and then, okay,
Right.
that's all right,
It's
cool.
the revocation proceedings that are open and pending. And so,
So they revoke my probation, then I'm stuck here again?
well, if they revoking, then talk to your lawyer, right, about how all of that works. And at that point, it gets a little nebulous, because it depends on how much time did you get in that case. Did you get time served? I don't even know.
Yeah.
So if you don't want to decide today, if you need more info, no pressure. You don't have to decide today. You just won't be back in court where you could waive until June 1st. If you want to punt, keep your rights. You can you can find out what happens on probation next week, but you'll be back in court in front of our fugitive judge on June 1st at 1:30. That's the next opportunity you'd have to waive, is June 1st. You can always waive anytime you're in court on the extradition case, but they're not going to take your waiver in probation court. Okay. I'm just your first opportunity. I'm not your only opportunity. So if you want to punt, that's fine. Just tell me that.
I'll wait.
Wait, great. Okay. I'm going to note that you keep your rights. And I'm setting your court date for June 1st at 1:30 in the afternoon. I'm setting the bond at $25,000 secured. If you do post it, don't leave the state. Don't miss any of our court hearings. Everything's on your paperwork. Just show your public defender next week and just say, hey, I also have this Missouri warrant. They can, you guys can try to game it out as best you can. They can't represent you in the extradition case because it's civil, but they can talk to you about how these things interact, And that maybe is helpful for you when you get to extradition court on June 1st to make a decision. Okay, let's get that printed for you, and then you're all done. We'll send it out to you, okay?
Could they always decide not to come even if I...
They can decide not to come. Yes, they can. All right. I don't... All right. Good luck, sir. All right, so officers, I've got Richard Rogers and Glenn Deering as house calls, as each of them not physically present in court because they've been isolated by the sheriff's office as a potential risk to themselves or others. All right, thank you. See, I like to keep it simple, so it's just a yes/no question. All right, then, and I did get some information about those defendants being isolated for danger to others before court as well. So I will go conduct the initial appearances for Richard Rogers and Glenn Deering in person, in-house, immediately after this hearing, or proceeding, I'm sorry. And I'll advise Richard Russell Rogers, Bill 4272. He's here in a new case. He got booked in for 3 things, which is unlawful flight from a law enforcement vehicle, a class 5 felony. There is probable cause for that. There's not probable cause for purposes of today's hearing only on the allegations of possession of narcotic drugs and drug paraphernalia. But I'll let him know they're not dismissed. I'm just ignoring them for release conditions, but there's definitely probable cause for unlawful flight. I'm appointing a lawyer for him, giving him a status conference of May 21st at 8:30 in the morning in the downtown Superior Court. Preliminary hearing May 26th at 8:30 in the same court. And in this case, it appears that Mr. Rogers has an extremely high number of prior felony convictions, could be as many as 19 of them. His last 2 were for unlawful flight from a law enforcement vehicle, and it appears he remains on parole for unlawful flight from a law enforcement vehicle. So this court finds that he is a flight risk and a high risk to the community. So bond is set, it's my intention to set bond in his case at $35,000 secured with written release conditions that do include calling his parole officer within 24 hours if he is released to the street. And it's my understanding there is likely to be a parole hold placed on him at the jail. All right, Mr. Glenn Deering, born 7/23/68, here in a new case. He got booked in for aggravated criminal damage of a school. That is a class 4 felony, and there is probable cause for it. I am appointing a lawyer for Mr. Deering. He'll have the status conference May 21st at 8:30 in the morning, the downtown Superior Court. Preliminary hearing May 26th at 8:30 in the same court. And based on his criminal history and these allegations, I do believe that he's not likely to comply with release conditions and appear for court in the absence of bond, and that he does pose a high risk of committing new offenses. So it's my inclination to set bail in the amount of $2,500 secured with release conditions I'll go over with him, which include not going to the scene of the alleged crime or having any contact with any witnesses there. If anything changes after I conduct these initial appearances, I will update the record by putting it in my written order. It's not my intention to have any further proceedings on this recording unless I have a reason to. My final decision will be in my formal written order. And with that, we are going to stand in recess until 2 p.m. this afternoon.